5, 4, 3, 2, 1. The learned additional sessions judge 3 Giridih dismissed the anticipatory bill application for the petitioner on the ground that the petitioner was a juvenile and as such his anticipatory bill application was not maintainable. Learned lawyer appearing on behalf of the petitioner submitted that a single bench of the High Court of Jharkhand at Ranchi in A.B.A. number 3600/2016 has held that provision of section 438 CRPC is not excluded under section 12 of the Juvenile Justice, Care and Protection of Children Act 2015, so the anticipatory bill application is maintainable. Reliance has also been placed upon the decision in Miss A versus State of MP as reported in ILR 2019 MP 662, wherein it was held that no provision in the Act of 2015, either expressly or by necessary implication, excluded applicability of section 438 of the code, which provides for grant of anticipatory bail. In the absence of any special provision dealing with grant of anticipatory bail to a juvenile/CICL, the provisions contained in the code regarding anticipatory bail shall be applicable. Reliance has also been placed upon decision of Chhattisgarh High Court passed in Sudhir Sharma versus State of Chhattisgarh as reported in 2017 SCC online CHH 1554, wherein it was held that the application for grant of anticipatory bail under section 438 of the CRPC is maintainable at the behest of the child in conflict with law on the ground that the said remedy is not excluded by operation of section 12 of the Act of 2000 or section 12 of the Act of 2015. Similarly, the High Court of Kerala in Mr. X Prashbu, son of baby VM versus State of Kerala as reported in 2018 3 RCR CRI 327 held that the provisions contained in section 12(1) does not take away the jurisdiction of High Court or the Court of Session under section 438 of the code even by implication, and the provision of anticipatory bail is not expressly excluded merely for reason that the Act provides for apprehending a child in conflict with law and not for arresting him. It cannot be held that the application under 438 of the code is not maintainable. Accordingly, it was submitted that the learned additional sessions judge Giridih has come to an erroneous finding that the anticipatory bail application was not maintainable as the petitioner was a juvenile. Learned Special PP appearing on behalf of the state submitted that a child in conflict with law cannot be arrested. As such, the question of granting bail in anticipation of his arrest does not arise at all. Reliance has been placed upon the decision of Calcutta High Court in Suhana Khatun and others versus State of West Bengal passed in CRM number 2739 of 2021, wherein the Calcutta High Court had held that a child in conflict with law cannot be arrested. Therefore, anticipatory bail application under section 438 of the CRPC was not maintainable. The bench which has passed the aforesaid order, however, referred the matter to the Honorable the Chief Justice of Calcutta High Court for the issue to be decided by a larger bench. The ratio behind decision of Calcutta High Court holding that anticipatory bail application filed by a juvenile under section 438 of the CRPC was not maintainable was on the ground that a child in conflict with law cannot be arrested, as section 12 of the Juvenile Justice Care and Protection Act 2015 provides that where a child in conflict with law is apprehended or detained by the police or brought before the board, such child shall be released on bail with or without surety, provided that such child shall not be released if there appears to be reasonable ground for believing that the release is likely to bring that child into association with any known criminal or expose such child to moral, physical and psychological danger. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.